morning. I'm Jason Barron. I'm a lawyer in the United States. It's a pleasure to be at the National Law School of India University for the first ever e-discovery conference here at the law school. I want to say that I completely agree with the Vice Chancellor in his remarks this morning that we are undergoing a paradigm shift. I hope all the students in the room know the term paradigm shift. What it means is that the law is being transformed as we speak. And the practice of law, the way that it was like in the 1980s after I graduated from law school, it's completely different in the United States today due to technology and automation and artificial intelligence. And so we're going to be talking about these subjects this morning and this afternoon, and I'm delighted that, in particular, that students are here because the future of law is in your hands. And for coming here today and for listening to some of the smartest lawyers I know who I brought from the United States and the smartest computer scientists I know, I think it will be of tremendous value to anyone who's attending this conference. So we have a bunch of talks this morning and some this afternoon, and I will make introductions as we go along. I want to set the stage by talking a little about what U.S. e-discovery means. And it may be a kind of a foreign concept to some people in the room. And so we want to have that conversation. And then I'll be followed by two computer scientists who will give their perspectives on what law and technology is all about.
Out of the 200,000, only 100,000 were relevant.
And then we'll have a panel
were off
with
by 50%.
all of us
That's a very inefficient
talking
process.
to you and hopefully with your questions.
What I learned more than a decade ago doing this is that
so let's just
when you do keywords
start.
and you're just looking at the
what
keywords,
is
you're not
discovery in the U.S.? What is
everything
e-discovery?
else that wasn't
Why
it.
is it
so
important?
If you type in keywords in Google, you get a bunch of listings.
We're going to
Or
talk
type in
a little
keywords
bit
to a
about
database,
searching for digital evidence, which is
that are
a
hit.
specialty of
What
some
about
of
the
us
documents
that
that
we've
didn't
cared about
contain
for
those
the last
keywords?
decade or
And so
decade and a half.
part of what we learned in e-discovery over the last
fact
decade
is that
we need to do quality control. We need to do
US discovery
sampling.
practice
We need to
is
evaluate
one
how
where-
well we're doing in e-discovery when you're searching large collections.
Happy to take it. In the United
That's all I'll
States,
say about that.
what everyone in this
so
room
there is
needs to understand
there are
is
these
that,
words that we use that we're going to talk
it is
about.
a
Our
right
panel here and
in U.S. litigation to receive information from the other side, from opposing counsel. And each side in a lawsuit has the right, in a civil lawsuit in particular, to demand that the other side give over documents and give over increasingly electronic data, documents in electronic form. You have the right to demand that of the other side. And it's very important to each side's case. The judge lets the two parties in the United States, in whatever court you're in, basically exchange demands for documents, for discovery. So discovery practice in the United States is a kind of fundamental right that litigants have to try to get the truth of what's going on, the evidence in the documents. It's very important, and it takes up a lot of time in the United States in the legal system, part of the discovery process. So the public has a right to every man's evidence.
Good way to
it is
gave a stamp
the
of
fullest
approval
possible knowledge of
in
the
New York,
issues and facts
and
before
lots of
trial.
judges follow.
That's paramount. That is
There's
of
case
high
law
importance
now
in the United States.
States
Elsewhere in the
about
world,
using artificial intelligence
there's more or less
to do
adoption of other practices, and to some extent
I have a
model
lot of
on
faith in artificial
civil
intelligence
discovery in the
and
United
machine learning
States.
as
Certainly in the
future
UK,
of the
there
law.
is a variant of it.
It's being used in many
Practice, and we can talk about how in India
discovery, but
it is increasingly the case for documents.
The question for the students here,
The United States is very important, but
you going
you
to
also
get a
have to
chance
understand,
in
and
your
this is a little hard
to
to
use artificial intelligence and machine learning in the
wrap your
software that we're
minds
talking
around,
about
is
in
that there's
searching for documents. It may well be that you never have the big case
no
that you
general
need
right to
search
privacy
for.
that blocks discovery in
There's
lawsuits.
corporations and
So
corporations in the US
there may be private information and there may be personal
the
information,
question is this
but
gonna be
that
part of
comes
your
up in the
life? If it
documents.
is,
But lawyers
you
have the
wanna
right
be
to
a subject
demand those
matter expert
documents
on this
nonetheless.
topic and learn
And
something
discovery
from us here
proceeds.
and from
There are ways
meeting
to
after the
deal
conference,
with
because you will
privileged
be able
information
to
and
get
personal information within the lawsuit.
step
But
up
you have the right to get
everybody
those
else who
documents,
doesn't know about the topic.
and increasingly in electronic form.
So that's all I want to say.
So I started my career
There's a
where it
movie
was
we're
all
gonna show this
paper.
afternoon to the
So
people
when I
who are
was
here this afternoon,
looking
but it's
for
available on
documents and
Amazon
evidence, it would be in boxes, in files, in traditional files.
what US
But
discovery
increasingly now
was
it's in
about 10
computers.
years ago or 15
And that's
years
what
ago
we're going to
now.
talk about in this
So I
conference.
recommend that.
The,
With that, I'm going
see
to
if I get it right.
sit down.
So there is still lots of paper, obviously. I saw that in a courtroom in Jaipur with Ashish, with paper files in India. And in the American courtroom, there are lawyers who come in with paper files, and there are still paper documents that are filed in file cabinets. But increasingly, the world is moving towards everything created on a computer. Everything starts off born digital. And then whether it remains digital, well, some cases it's printed out, and that's documents to get in discovery, but increasingly it's electronic, and especially when you get to the cloud and the network of computers around the world, data is everywhere, and it's sitting on some server, on some computer, somewhere, whether it's in the United States or in India or somewhere around the world. And all of the social media that we all use, our data is up there. And in US litigation, in many lawsuits, there are demands to get that information from the other side, to pull it back, to see what's there, that's in the cloud. So we deal with both computers in corporations, in corporate networks, and increasingly on social media. What is e-discovery? It refers to discovery in legal proceedings, or in investigations, or in access requests under Freedom of Information laws, where the information is sought in electronic format. It's often referred to as electronically stored information. So you'll hear some of us say ESI. ESI is electronically stored information. Those documents in electronic form, data in electronic form. Subject to the rules of civil procedure in the US and in other countries. It involves a review of the documents for relevance and for privilege, and we can talk about that. And in electronic information is different than paper information because of an important thing called metadata, and I'll talk about that in a moment. That's all I want to talk about in that slide. The preservation of metadata from documents creates special challenges, and we can talk about that. So this is a widely recognized model, so the law students should all type into Google Electronic Discovery Reference Model, or EDRM, and this shows the stages of e-discovery as practiced in the United States. Let's put aside information governance, which talks about records and storing records and managing them. Put that one aside. These different stages consist of what e-discovery is all about. And so we can talk about identification of ESI, of electronic information, preservation of it for lawsuits. Very important in the United States. If you file a lawsuit, you make a demand, as a lawyer, you make a demand to the other side to preserve all of your ESI so that it doesn't get destroyed or deleted. And there's lots of case law about failure to preserve information. So preservation is very important in electronic discovery. The collection, sorry, I keep touching the screen and it goes up. The collection stage, collecting what's relevant and what is within the scope of a lawsuit. That could be millions of documents in millions of emails, millions of documents in electronic form. And then there are various stages that lawyers do in e-discovery, known as processing, review, analysis, and eventually production. And each of these stages means looking at the electronic evidence that's been gathered and finding the relevant documents within a much larger universe of documents and litigation. And how much? It could be, some lawsuit might only have 100 records, or documents. Some could be 1,000, some could be 10,000, 100,000, 1 million. And I've asked US lawyers, what's the largest lawsuit that, in terms of terabytes of data? And some, get an answer like 200 terabytes of information that they had to look through in electronic discovery. So the the collection and the preservation are huge demands on the system. Okay, so the types of information that are involved in e-discovery, email, word processing, spreadsheets, we all know about those. Those are, we have lived with that for decades now. But audio and video files, backup tapes get wrapped up in litigation where there's a demand to save backup tapes on computers. That's something that is not understood in other countries very well, that we have that demand. Databases of all types, social media of all those applications that are out there, communications apps like WhatsApp or Slack or Confide or Signal or whatever. Thank you.
And so way beyond email. And the Internet of Things with all the smart devices that exist in the world and increasingly are being dreamed up. They all have data which could be subject to gathering of evidence in litigation. And there are legacy devices and, smartphones and objects of all kinds. And so all of this is fair game in U.S. litigation. If you have a lawsuit and you make a demand to the other side to give me all your relevant documents, give me all your documents related to the lawsuit, that means sometimes collecting smartphones and examining the contents of the smartphones, or collecting whatever devices or laptops or what's on a computer, that anything that could be relevant to that particular lawsuit. You can make that demand of the other side. If you're one party and the other party is a corporation, you can make that demand of a corporation, and they have to do a reasonable job searching for that, or they might be subject to some kind of sanction in the court. Metadata is the data about data that's contained in a computer system but not necessarily printed out. So there's more information about the electronic objects in the metadata, and there are lots of cases where it's important to know who knew what when, and the metadata will provide kind of a timestamp. It will say when that email was sent, when the document was opened, and other kinds of, who was the author in various drafts. That's important in U.S. litigation in some cases to find out, to tell a story of who acted on a particular document. And it's also important for authenticity generally and for the trustworthiness of the information. We are living in a world where the data is increasing like this. That's especially true of the Internet of Things. The question about when we have all of this data, the complexity of it, the size, the vast quantities of it, how do we find relevant information? And that's a conversation that has animated myself and Doug and others here for more than a decade, how to be efficient in searching. I've already mentioned smartphones, so I won't go on. It's an explosion in India about smartphones. In the US, smartphones can be collected as part of litigation and searched for relevant documents that are on them. So e-discovery is here, and there is kind of a minefield for lawyers in the United States to get it right, to do e-discovery correctly. And so you need to be competent, and you need to focus in your efforts to understand the technology that's involved and to actually accomplish how to collect, how to preserve, how to review, how to search. That's important. So litigation increasingly demands preservation of electronic stuff. Courts may impose sanctions, and courts are increasingly expecting that reasonable searches be done in an automated way, not through manual looking at every object or whatever, but using software to search through to find evidence. Searching the haystack, everybody knows haystacks and needles, finding a needle in a haystack. So the thing is that for us lawyers, we're not looking just for one needle in a haystack. We're looking for all the needles, all the relevant evidence that could be possible in a lawsuit. And so the question is, what's a reasonable search? When you're looking through 100,000 or 1 million emails, how do you know you've done a good job? How do you know that you've found everything? And that's a question Doug and I in particular were asking more than 10 years ago. And we started a research study called TREC, the Text Retrieval Conference, and maybe Doug will mention. And we want to find as lawyers all the needles, and we want to do it in a way that and not find all the stuff that's not there. So we want to separate out the wheat and the chaff, and we want to do that efficiently. And from my perspective, and I'm not going to go much longer here because of time, but we started as lawyers with keywords. Everybody types in keywords to Google and whatever other search engine you have. But it turns out that keywords are a very inefficient way of searching through evidence. It gets you some of the way, but my experience as director of litigation at the National Archives when I had to search through White House email because of a tobacco lawsuit is that I hired 25 people to search through 20 million emails, and it took 6 months, and we came up with hits based on keywords, but the process was very long, and it turned out that while we found 100,000 relevant documents, it was a process where there were 200,000 documents that we actually had hits for with keywords, typing in tobacco, smoking, nicotine, using keywords for this tobacco case. But out of the 200,000, only 100,000 were relevant. So the keywords were off by 50%. That's a very inefficient process. And beyond that, what I learned more than a decade ago doing this is that when you do keywords and you're just looking at the keywords, you're not sampling everything else that wasn't hit. So if you type in keywords in Google, you get a bunch of listings, or you type in keywords to a database and you get a bunch of documents that are hit. What about the documents that didn't contain those keywords? And so part of what we learned in eDiscovery over the last decade is that we need to do quality control. We need to do sampling. We need to evaluate how well we're doing in eDiscovery when you're searching large collections of objects. That's all I'll say about that. So there are these words that we use that we're going to talk about on the panel here, and others will talk about, called technology-assisted review or predictive coding. And so for the students in the room, you should write down predictive coding and technology-assisted review and type those into Google and read some articles about it. And we have some references in handouts that Capstone will give. But it is basically software that allows you to be much more efficient in searching through large amounts of data. And that's all I'm going to say about it for now. I'll go past the slide, and I'll let Doug and others talk about it this morning. But it's a new way of doing business as lawyers. It involves artificial intelligence and machine learning. The software learning what is a relevant document. It's much more efficient than keywords. And if there's one thing that I want the students here this morning to understand is that in the US eDiscovery practice, the smartest law firms and the brightest people are now using artificial intelligence to search through large quantities of data. That's the point. And a judge in 2012 said that was a good way to proceed. A judge gave a stamp of approval in New York, and then lots of judges followed. And so there's case law now in the United States about using artificial intelligence software to do document review. And I think that's important to know about. I have a lot of faith in artificial intelligence and machine learning as the future of the law. It's being used in many different ways. We could talk about it not just in Discovery, but this is a eDiscovery conference. The question for the students here in particular is, are you going to get a chance in your career to use artificial intelligence and machine learning and the kind of software that we're talking about in searching through documents? It may well be that you never have the big case that you need to search through 1 million documents or 100,000, but you might, because corporations in India and corporations in the US have huge amounts of data to search. So the question is this going to be part of your life? And if it is, and you want to be a subject matter expert on this topic and learn something about it from us here and from reading after the conference, because you will be able to get a step up from everybody else who doesn't know about the topic if you know something about it. So that's all I want to say. There's a movie we're going to show this afternoon to the people that are here this afternoon, but it's available on Amazon that explains the story of what US eDiscovery was about 10 years ago or 15 years ago and now. And so I recommend that. And with that, I'm going to sit down.